Hi, my name is Cheryl Stein. I'm a criminal defense lawyer in Washington, D.C., and I'm going to be talking to you about the evidentiary concept called the rule of completeness. In the federal rules of evidence, this is Rule 106. In your state rules, very often the state rules track the federal numbers, so it may well be Rule 106 for you in your state, but possibly not. It is a common law doctrine. It has been around for centuries. Every jurisdiction recognizes some version of it. Under the federal rules of evidence, the rule is, if a party introduces all or part of a writing or recorded statement, an adverse party may require the introduction at that time of any other part or any other recorded statement that in fairness ought to be considered at the same time. The advisory committee note, which should always be read when dealing with a rule of evidence, says, the rule is based on two considerations. The first is the misleading impression created by taking matters out of context. The second is the inadequacy of repair work when delayed to a point later in the trial. So the point of this, of course, is if your opponent asks a witness something that takes something from a writing or recording out of context, the jury will be hearing it through a distorting filter. They will not be understanding the full import of it. And what the rule is saying is if you have to wait to correct this misimpression until you're cross-examining that witness, a lot of damage may already have been done. So the purpose of this rule is to let you fix the misimpression immediately. It is one of those rather rare situations where you get to stand up and ask questions in the middle of the government's direct. The other times where that occurs, for example, is if you're voir direing on whether something qualifies as a business record, or you're voir direing a witness who's been offered as an expert because you may want to object to the expert credentials. What you do is you have to stand up while the prosecutor is examining and say, Your Honor, rule of completeness, may we approach the bench to discuss it further. There are some key splits in federal case law about this rule. As you've already seen, the rule by its terms applies only to writings and recordings. There are some circuits that have held that the rule can also be applied to oral testimony. And the reasoning of those circuits, I do believe this is a minority rule, so you do need to check. But the reasoning of those circuits is that Rule 611 gives the court discretion to control the order and manner of the presentation of evidence. So what those circuits have ruled is, since the judge has control over that and can always take a witness out of order if he or she wishes, that the rule of completeness encompasses that testimony. There are circuits that have ruled to the exact opposite and do not allow that, so you need to research it for your jurisdiction. The other key split in this area is whether or not the rule allows you to introduce evidence that would otherwise be admissible but is relevant to the completeness. And that is a very sharp circuit split. I don't know why the Supreme Court has never resolved this, but they haven't. So you do need to check that for your jurisdiction to see which way it goes. As I said, this rule exists everywhere because it's a common law rule, but this is a rule where there are some significant differences between some state rules and the federal rules, so you need to check that. Some state rules are broader and some state rules are narrower. Just off the top of my head, for example, common law in D.C. is much narrower. You are only allowed to introduce other portions of the same writing or recording. You cannot use any other writing or recording. The federal rule explicitly allows that. Some states are much broader. Off the top of my head again, I just happen to know that Iowa has its rule extend to both conversations and acts. So that lets you get in much, much more information. You can not only get in conversations, you can get in gestures, people winking or crossing their fingers, which suggests that what they're saying is not true. So be sure you understand what the rule is in your jurisdiction. Timing. The rule, by its terms, clearly allows you to do this during the government's direct examination. That does not mean that you can't do it again on cross or during the defense case. You can do both of those if you have a defense case. So if you have done the rule of completeness during direct on one of the government's witnesses, and now you're cross-examining, and you go into the same subject matter, if the prosecutor objects on an asked and answered ground, that will be overruled. You have an absolute right to continue to examine it during your cross, and if you have a witness during your defense case who can shed some light on it, you can bring it up yet again. So it is not as though it's an either or. You don't have to choose whether to do it during the government's case or your cross-examination or your case. You can do it in all of them or any of them as you see fit under the facts of your case. There are, of course, significant tactical considerations. Just because you can do it doesn't mean you necessarily want to. Just as you don't make every objection that you could make because sometimes it's better just to let things go. It is impossible for me to give you any kind of clear guidance about when you should do it and when you shouldn't, because that depends very specifically on the facts of your case. I will say generally for me, if I have a real smoking gun, if the witness is really just lying or the government is being unethical in deliberately leaving out something that completely changes the meaning of what they've introduced, I tend to wait until my cross-examination because that can give the witness a feeling of overconfidence that he or she is getting away with the story they're being told, and then you can suck them in. And if you do have a smoking gun, if you have a written statement by that witness or a recording that shows they're lying, I like to save it and sort of zing them with it in my case. If it's something more subtle, where it's just a change of context or it changes the shading of the meaning, that would incline me to do it earlier because you don't want the jury to hear this slightly off-shaded information, because it's harder to go back and reevaluate something subtle like that than it is to go back and say, oh, everything he said was a lie, so I can disregard everything else that he said. I would say that when you're inexperienced, you should probably err on the side of doing it as often as possible because you won't yet have the judgment to know when you can really bury the witness.